Hi, everybody. Welcome to part 3 of the course. If you're following along in the syllabus, we are currently at week 10, and these are the PowerPoint slides for Tuesday, October 31st. I apologize for posting them a little bit late. Took me a little longer than I expected to grade the exams, but nevertheless, here we are. So, on tap for today, I want to talk a little bit about the midterm, kind of broadly, and what I thought about your tests, and then give you some stats about the grades and how you guys did on various components of the test. And then I want to talk about the case study assignment, which we haven't gotten into yet. It is now posted on Blackboard in a folder called Assignments that you can find at the bottom left of our course's Blackboard page. It is due on December 5th, which is a Tuesday. It's a week before the final exam, and the reason why it's due a week before the final exam is I'm hoping to have them graded so that you know your grade on the case study assignment before taking the final exam. So we'll talk about that. And then we will transition to part 3 of the course, which is really about focusing on the role of law and courts in specific policy areas. And this will allow us to continue to probe Rosenberg's dynamic and constrained court view debate. And in this particular week, we're going to be talking about how the courts cope with modern technology via tort law and insurance. So essentially here, we're going to be discussing methods of compensating victims of wrongful and unexpected injuries. And this is something that is endemic to modern societies. The U.S. is not alone in sort of using insurance regimes as well as certain compensation practices that are court-based. Yet, as was the case with adversarial legalism, the American way of doing this has both changed over time and is different than in other places. And so we'll talk about how that applies to tort law and insurance as we go. The way that America does this has some positives and some negatives, which we will discuss, with the end goal of looking to generate hypotheses about the nature of constraints on judicial policymaking in the U.S. And this ties in directly with what you need to do in the case study assignment, which I'll get to in just a second. But first, to the midterm. So this is something I do in all of my classes. Normally it's something that I do in person when my classes meet, but given that we're a hybrid course, we'll talk about the midterm grades here. So overall, I'd say that I was very sort of happily surprised by the midterm grades. I thought that they were really good. And I'll go through each section of the test here and talk about each component. So starting with the IDs, the average ID grade, which you can find there in the row that says ID total, was 22.93 points out of 30. That's good for 76%. And as I mentioned in class, I graded the components of the test individually. So I graded all of the IDs first, all of the short essays second, and all of the long essays third. And I tried to do it blindly when I could. So there were 10 IDs. You had to answer 5 of them. They were worth 6 points each. And as you can see, the grades were really actually remarkably consistent across the IDs. Normally there are a few outliers, some that are really low, some that are really high, but you guys tended to do the best on bureaucratic legalism, although maybe not surprisingly, that was also the one that the fewest number of you answered. So if you look at the column on the far right called N, that is the number of students who answered each ID. So the most popular ID was self-help, followed by plea bargaining, followed by political failures, and then followed by orderly dispute resolution and US v. Nixon. And then doctrinal constraints, one-shotters, majoritarian politics, and bureaucratic legalism rounded out the order of most popular to least popular. So again, I'd be happy to talk about your specific tests at some point with you. If you have questions, I'll be passing them back the next time we meet on November 14th. But in the meantime, if you want to make an appointment to come to office hours, I'd be happy to give you the test back On the IDs, I was looking for three things. I was looking for you to correctly define the term, identify its significance or its relevance to the course, and this usually required tying the specific ID term to other concepts that we've talked about. And then to the extent applicable, you needed to provide an example. So moving on to the short essays, this is really where you guys tended to do really well. So the vast majority of you answered short essay number 2, and you did so in a pretty good way. So the average points there, 13.48 points out of 15, good for 90%. Short essay 3 was the second most popular at 85%, and short essay 1, which 10 of you did, you guys averaged 13.25 points on that one. And your long essays were really good as well. 33.57 points out of 40 was the average, which is good for an 84. As for the extra credit, Robert Kagan was the one who came up with the term adversarial legalism. I got a lot of creative spellings of Kagan, but if you gave it a whirl, I pretty much gave you the points. And then as for vagrancy type laws, that was Caleb Foote's article that we talked about right before the midterm. So 12 of you, about a third of the class, got both of those questions correct, good for 4 points. One of you got 3 points, 12 with 2, and 9 of you got 0 points. So the average grade for the midterm without extra credit was an 82.81%. And once we factored in extra credit, which again was worth up to 4 points, the average grade jumped to an 85.01. The high grade for the class was actually the highest possible grade on the exam, which was 104, which one person got. And then one of the things that I was really impressed about is when you factored in the extra credit, actually 7 people in our class, which is good for more than 25% of the course actually, received, well, almost 25%, but 7 of you actually earned grades over 100, which was pretty amazing. So it seemed to me that there's a subset of the class that really is getting it and doing really well, and then there were also a handful of you who earned D's and F's. And so for those of you who are in that boat, we'll talk about the final exam before it happens, but I think, they say the definition of insanity is doing the same thing over and over again and expecting a different result. So if the result for you on this exam was not quite what you wanted or what you expected, you need to change some things in anticipation of the final exam. So I'd be happy to meet with you in office hours or answer questions by email or via phone if you want to talk about your final exam. All right. Sorry, your midterm exam. Okay, so anyway, on to the case study assignment. So as I mentioned, the assignment itself is posted on Blackboard in the assignments folder. And the idea here is for you to apply the dynamic court view and constrained court view to a Supreme Court case, a U.S. Supreme Court case that you pick yourself, and you research the various constraints and you come up with a thesis about whether the court was acting dynamically or constrained or some combination thereof, and then you spend the paper defending your thesis. So as for steps to get started, you need to first look for a potential Supreme Court case for analysis. It needs to be a recent Supreme Court case, so from 1990 to the present. You should, maybe before doing this even, or as a way of doing this, identify a policy area that really interests you. So the war on terror could be one, intellectual property could be one, voting rights could be one, healthcare could be another. So rather than try and find a case without sort of thinking first about what you're interested in, instead really drill down your interests and then maybe try and find a case from there. So a good place to search is the CQ Weekly database, which is available through the TWU Libraries website, and you can do a keyword search with whatever topic you're interested in, along with court. You could also do this in a Google search, but the CQ Weekly database will help you get more sort of responsive results. So your next step is to read about the case generally. So once you've picked the case, read about it. Don't necessarily go straight to the case and the ruling, because these rulings are often filled with kind of inscrutable legal jargon that may be difficult to understand. So a good place to go would be newspapers, the New York Times, the Wall Street Journal, the Washington Post, etc., all of which are available through TWU libraries. And then turn your attention to databases to find the case itself. So LexisNexis Academic is a good place to start. SCOTUS blog has, if you just do a Google search for that, it has a bunch of information on a lot of cases, along with OYEZ, which is OYEZ, and I believe it's at oyez.org, but you can just Google it. This will allow you to obtain a copy of the case as well as the briefs that the attorneys filed in the case. So as for the process, you need to think about summarizing the case. You can do so using newspaper accounts, law reviews, and the case itself. You need to think critically: what was the issue, who were the parties in the case, who won, and why. And then, after you've done that, you need to start thinking critically about the various constraints and how you would apply them to your case. So, of course, the constraints, as we've mentioned many times in class, are doctrinal, institutional, and cultural. As for doctrinal constraints, the source of these for your research purposes are the case itself. Law review articles are also quite helpful in this regard. And you need to identify the issue, you need to identify the parties, you need to identify who won, along with why. Sometimes these questions will shed light on whether the court found itself to be doctrinally constrained or not. As for institutional constraints, source here may be CQ weekly databases along with newspaper articles. And as you're well aware, institutional constraints are divided into two groups, external and internal. So as for external institutional constraints, you need to think about or do some research to find out whether the other branches responded to the court's ruling. If they did respond, how did they respond? Did they pass new legislation? Did they attempt to override the court's decision? You also need to figure out whether the court divided itself along partisan or ideological lines. OYEZ is a good place to go for this. And as I'm sure you're aware, but just in case you're not, a good way to figure out how the case divides itself along partisan lines is to think about who nominated the particular justices on the court. So the court right now is split so there are 9 justices. So split 4-4 with 4 justices firmly in the conservative camp. So here you have Neil Gorsuch, Trump's newly confirmed justice, Samuel Alito, Chief Justice John Roberts, and Clarence Thomas. You also have 4 judges who are primarily considered liberal judges: Elena Kagan, Sonia Sotomayor, Stephen Breyer, and Ruth Bader Ginsburg. And the 5th justice, Anthony Kennedy, who was nominated by President Ronald Reagan, is considered a swing vote and sort of goes back and forth between voting with the conservative bloc and the liberal bloc. For example, he wrote the majority opinion in Obergefell versus Hodges, which was the Supreme Court case that famously legalized gay marriage across the country in 2014. So just some stuff to think about there regarding external institutional constraints. As for internal institutional constraints, you need to think about whether or not the court was well suited for dealing with the underlying issue. Were there constraints about who could bring the case to them, or there are constraints about how they were organized, etc., as well as what was the case's impact. As for cultural constraints, the sources here that are a good place to look are editorials from newspapers that I mentioned before: Wall Street Journal, New York Times, Washington Post, along with polls from organizations like Gallup or Pew. And so what you want to do with the cultural constraints is really get a sense of whether or not the court was following public opinion broadly in ruling on this issue, or were they going against public opinion? Were they dealing with an issue that the public doesn't particularly care about, etc.? So another good place to look is what are called amicus curiae briefs, and this is really Latin for friend of the court. OYEZ is a good place to find these. And so you can often find here that businesses, sometimes attorney generals at the state level, filed briefs to argue in favor of one side or another in the case, and this gives you a little bit of a sense about how the public may feel about an issue. Public opinion polls clearly here are important. As for elite opinion, the briefs and the newspaper editorials could be a good place to look here. And then you just need to be thinking about whether the case is consistent with these types of cultural constraints. So the essential outline of the paper is as follows. You need an introduction, and in this introduction you need to briefly introduce your case, and at the end of the introduction you need to include a thesis. And your thesis, there are a few different ways that you can sort of go about writing it, but you could say something like, this case is an example of the court acting either constrained or dynamically in the face of strong institutional constraints, strong doctrinal constraints, or strong cultural constraints. And we'll talk about what the constraints really need to look like in order for the court to be dynamic or constrained. We'll talk a little bit about that today. The second part of the paper should be a summary of the case, where you identify the major issues, the major players, the decision, the ruling, etc. And then you need to go into the constraints one by one. And using research, you need to tell me whether or not these constraints were particularly powerful or not. And so generally what we see is that if just one constraint is strong, then that could keep the court from acting in a dynamic way, right? So in other words, even if they were able to act powerfully in terms of their sort of institutional arrangements, and if public opinion agreed with the court broadly, they still might not be able to overcome really strong doctrinal constraints, right? So generally we see that when the court acts dynamically, all three of these constraints need to be quite low. And when the court is constrained, it just takes one of these constraints to be strong to keep the court from acting. And then in your conclusion, which is the last part of the paper, you should restate your thesis. This is just good practice no matter what kind of paper you're writing, and then offer broader lessons about the courts and judicial policy making. So again, this paper is due on December 5th. I'll talk much more about it in class on November 14th. But in the meantime, go to Blackboard, download the assignment prompt, and start thinking about some of these questions. All right, so moving on. Oh, one more thing I wanted to mention. The next discussion board post is due before class starts on November 14th. So you have a couple weeks, and it'll be about this material and next week's material as well. All right, so moving on to part 3 of the course, where we talk about how the courts have sort of, or not how the courts, but how we can apply the dynamic and constrained court view to various issue areas. And so what we're going to be talking about today is generally the courts dealing with evolving technology. And for our purposes, what we think of we're sort of thinking of technology very broadly, right? So we're not talking about the iPhone or whatever. Instead, we're talking about just how society as a whole has changed from the late 1700s, of course, when U.S. government was organized, to now. And so during that time period, a lot of important technological changes have happened, including most notably the Industrial Revolution. So technology and technological innovation have obvious benefits for a populace, right? It doesn't take much for us to look around and think about all of the ways that our lives benefit in the face of technology. Examples here are too numerous to count, but let's just use vaccines as one. So I'm not sure how familiar you guys are with vaccines as a policy issue in the United States, and here I'm not talking about vaccines causing autism or anti-vaxxers or anything like that, but instead vaccines have really enormous benefits for the population, right? So the U.S. was able to essentially eradicate polio because of widespread polio vaccination efforts. Young children are now vaccinated against, hepatitis A, hepatitis B, pertussis, diphtheria, all sorts of things. And these really have huge benefits. They've lengthened the lifespan of Americans and of citizens across the world. Yet something that drug companies need to consider when creating these vaccines is that some portion of the population, which is usually very small or even infinitesimal, will have negative sort of biological or physiological reactions to these vaccines, and that inevitably there will be side effects that will affect some people negatively. And so the court needs to figure out, or not the courts, but rather these vaccine makers need to figure out, okay, how do we balance this need for the greater good with knowing that we're going to injure some people sort of inevitably, right? And so the personal choice not to get vaccinated has a really large influence on others. And so, despite efforts to improve the distribution, the marketing, and the testing of technology, there's nothing really that can be done about harmful and defective technologies, along with the perception of harms and threats. There's really nothing that can be done about those inevitably emerging. So, as technology advances, again, people's lives will be saved, but at the same time, other people will be grievously or potentially fatally injured. So, in a fast paced, mobile, and affluent society, such as we have with well developed transportation networks and distribution channels, the risks of technology, like vaccines, are quickly amplified and widely distributed. And so, this is a dilemma that's faced by many, and it's what I just touched on. How do you compensate victims of unsafe technologies in a way that makes sense and manage future risks without chilling innovation too much? And what I mean by chilling innovation is, in the case of vaccine makers, making it so expensive to compensate victims of their technology that they can't afford to make vaccines anymore. And this is something that the US legal system dealt with in the 1980s in the face of a rising number of lawsuits about potentially grievous side effects of vaccines. And so, in order to get a handle on this problem, the US Congress passed legislation creating special vaccine courts. And essentially, here, the vaccine makers, no matter what the vaccine is, they pay essentially a tax, that they pass along to consumers. But $1 for every dose of vaccine is paid into this fund, which then distributes money to victims of vaccine-related injuries. And if you're thinking that this sounds like insurance, you're exactly right. So the court has been really involved in this process almost from the beginning in terms of addressing risk, thinking about injuries, thinking about potential risks to the environment, which is something that we'll talk about next week. All right, so let's break down tort law versus insurance, which really is kind of at the forefront of what we're going to be talking about today. So both tort and insurance have to do with injury in society. So tort law is a branch of civil law, so not criminal law, but civil law, that deals with wrongful acts involving injuries to a person, property, or reputation. And for you future attorneys out there, just be aware that this excludes damages that results from breach of contract, which is a different issue of law or a different area of law altogether. Insurance, on the other hand, is a private contract or public program that is aimed at compensating injury victims and that spreads the risk of individual loss. So how does it do this? I assume all of you are familiar with insurance in some form or fashion. If you have a car, you're of course required to have auto insurance. Americans now are ostensibly required to have health insurance in some way, although the penalty for not having health insurance is not particularly great at the moment. So the way that insurance works is that everybody pays a premium every month, right? So if you have car insurance, you pay your insurance premium every month. Let's say it's $85. And then the idea is that when accidents happen, as they inevitably do, especially when cars are involved, you go to your insurance company, you file a claim, and you then receive payment or compensation for your injuries or for damage to your property, right? So the key part of insurance is that it pools risks, right? So what it does is essentially, and for those of you who have been paying your own car insurance since you turned 16, you know that insurance companies do not treat all drivers the same way, right? So 16-year-olds who drive, fast cars are inherently a bigger risk for insurance companies and compensation than a 65-year-old driver with a clean driving record. And so as a result, a monthly premium for a 16-year-old is going to be much higher than it is for a 65-year-old. So insurance has a lot of benefits, especially on the business side, because What it allows insurance companies to do is to pool the risks among lots of different people, right? So the people who are always safe, never get into an accident. They have to pay into the system just like people who get into lots of accidents do. And the same goes for the health insurance market, any form of insurance. We also have public insurance programs in the United States as well that are federally funded programs that companies, usually within a single industry, pay a tax on production of goods. That money is then pooled into a fund, which then people who have been injured by those products can apply for compensation from that fund rather than fighting these individual tort cases in court. So one thing that applies very much to my own research is the Black Lung Compensation Fund, which I've talked a little bit about in class, I think. But what the Black Lung Fund does is it requires coal companies to pay a surtax on every ton of coal that they mine, and that surtax goes into a fund that is administered by the federal government to pay out damages and compensation to miners who get black lung disease, which is sort of an inevitable byproduct of spending a career down in a coal mine. And so the coal companies actually really like this a lot because even though they have to pay a tax, it allows them to plan for contingencies, which can be really good in terms of sort of making your shareholders happy, and it allows the coal companies to spread the risks of black lung disease amongst themselves. So in the United States, we handle injury compensation through a mix of tort law and insurance that is both private and public, to deal with unintended accidents. So we commonly ask two questions in this course, which is how has U.S. law changed over time, and how does U.S. law differ from similar countries that exist, elsewhere in the world? And so, looking at the big picture and how U.S. tort law has changed over time is pretty instructive for us, and it's essentially the story of the rise of adversarial legalism. And it starts in the shadow of the Industrial Revolution, when accident compensation was a pretty sleepy, very little used area of the law to a major source of litigation. And why is this the case? Well, in short, it was the case because railroads do more damage than horses, right? So as the U.S. Progressed down a path of industrialization, the frequency of unintended accidents caused by technology increased. To injure people, injuries are just going to be less numerous than in a really industrial economy where workers are dealing with really dangerous products and processes. So we see that the courts have really changed over time in how they've understood tort law and have treated tort law. And so one case that's worth noting is the Supreme Court case of Brown versus Kendall, which took place in 1850. And essentially the principle here, which is what they call a principle of negligence, is that we all owe each other a certain degree of what the courts have called reasonable care. And the example in the case is that Mr. Kendall sees a dog fight. His dog is fighting Mr. Brown's dog, and Kendall decides to take care of it by hitting the dogs with sticks, which doesn't necessarily seem like the best approach, but I guess that's how you fixed a fight between dogs in 1850. And in the process of hitting the dogs with sticks, he accidentally hits Brown in the eye. Brown wants to sue using tort law, and the court finds that Kendall can be held accountable for actions only if his actions fell short of quote-unquote ordinary care. So we'll come back to this in a second. So tort law through the 1800s and into the early 1900s starts to evolve into something called proximate cause. So there's really no question of negligence in this case that I'm about to talk about, which is Ryan versus the New York Central Railroads. And here, due to the railroad's negligence, as trains were passing by Ryan's house, sparks from the wheels of a locomotive started a brush fire in a populated area. That brush fire spread to Ryan's home and destroyed it, along with several other properties in the area. And in this case, the court ruled that the railroad is not liable because its actions were not the quote unquote proximate cause of Ryan's injury. And the policy question here that the courts were dealing with essentially was, how do we deal with victims of modernization? And I'll get more into this in a second, but what the courts essentially were saying is that economic development and the Industrial Revolution at this point in time mattered more to U.S. policymaking than compensating victims. And that may no longer be the case, as I will get into in a second. So essentially in the 19th century, the court was, and into the early 20th century, the court was an economic development regime. So they were more likely to rule in favor of businesses such as the railroads here because they did not want to chill innovation too much. So they applied a set of rules that provided very narrow causes of action for plaintiffs who were looking to sue based on tort law, and very broad defenses for businesses to use. And what this meant is that it was really difficult for people who had been injured due to emerging and evolving technologies to obtain compensation. And this changed in the 20th century. As we've seen in a lot of this class, the courts in the 20th century underwent a real shift in many ways. And so from the 19th century, where the court was part of kind of economic development, they moved in the 20th century to being part of a compensation regime. And so here they provided a set of rules that provided for much broader causes of action. So in other words, saying that plaintiffs could sue for a more broad and sort of easily met set of conditions, along with fewer defenses for businesses, which made it much easier for people to obtain compensation. And in both periods, the courts were very, very central to designing, crafting, and making injury compensation policy. So why did this shift happen then between sort of this economic development regime and a compensation regime? So Kagan argues that in large part, and also Friedman, which are the two assigned readings for this week. So Kagan argues that it was a multitude of factors, but one, that the widespread nature of insurance in the 20th century has really eliminated the risk of bankrupting key businesses. And so then the court doesn't necessarily have to focus as much on making sure that, the New York Central Railroad is not hurt too much by burning down Ryan's house, right? There has also been an accompanying rise in the public's expectation for compensation. And this has happened both because of the rise in insurance and the liberalization of tort law. So now, as Americans, we assume that if we are injured in a way that is not our fault, right, or ostensibly not our fault, one could argue that Ryan should not have built his house right next to the railroad, right, or should have moved once the railroad moved in. But nevertheless, this shift has really caused us as the American public to expect somebody to compensate us when something bad happens. It may be that our insurance companies step into the void to compensate us. It may be that we hire an attorney and file a tort lawsuit. But nevertheless, we expect compensation. Also, technological advances have changed, and workplaces are now safer. Products are industrially designed in a safer fashion. And there's also been an increase in what we call social distance. And so here, it's this idea that people are more sort of separate from one another than ever before. And as a result, when disputes arise between workers and employees or between various workers, rather than turning to self-help or a system of mutual accommodation, we rely to a greater extent on the courts. And so collectively, these represent a rise in what we call total justice, which is this overall expectation for compensation and this sort of demand that we receive justice for any wrongs that have happened. So a few quick side notes. So one, if we live in an age of total justice, which Friedman and Kagan argue, then how does one explain the rise of tort reform measures in the 20th century? And tort reform, if you're unfamiliar with it, Texas is actually sort of ground zero for tort reform legislation in the United States. But tort reform refers to laws that are designed to limit people's recourse to the courts, and that's essentially their ability to file injury lawsuits, as well as limiting the amount of damages that people can sue for or can recover. So, for example, in California, medical malpractice cases are limited to $250,000 in the case of injury due to medical malpractice, no matter how severe the injury is. So, one answer is that many tort reform measures only work on the margins. So, rather than sort of replace wholesale our system of adversarial legalism, they only cap damages or they make it harder for people to sue, not necessarily replacing the system as a whole. We'll talk more about this later. And additionally, tort, if you look at the numbers, is actually only a small part of a much broader compensation regime that, again, like we said, features public and private insurance as well as lots and lots of adversarial legalism. And finally, consistent with what Kagan says about the sort of recipe for adversarial legalism in the United States and why it's grown over time, Kagan argues that demands for total justice, despite increasing in the 20th century, have not displaced the traditional individualistic political culture that America holds very dear. And so as a result, we see this tension, this dichotomy between our expectation for total justice and the limits of the court system in America and actually providing compensation for us. And by the way, other countries, especially those that follow bureaucratic legalism, they treat this topic really differently than we do, right? So they have, for example, nationalized universal health care, which may provide their citizens with compensation in case of, occupational disease or whatever, whereas in the United States, we have what is seen as a pretty weak social safety net in terms of welfare. So as a result, Americans are forced, despite the fact that the courts may sometimes not be the best venue for seeking compensation. And so, anyway, tort reform can be seen as sort of a reassertion of these traditional values. Side note number 2 asks, should the courts have rewritten tort law at all? Is this something that the court should have gotten involved in, this process of injury compensation? And there's a couple arguments here. So the argument for yes is that workers, as America was industrializing, faced very powerful and well-organized companies. This is the era of monopolies, so you're thinking here of Standard Oil, of course, John Rockefeller's, mega monolith monopoly. And these well-organized companies, so in addition to Standard Oil, like the railroads, Vanderbilt, etc., had essentially captured the political process at the time. And so legislators were more intent on protecting the financial well-being of these companies than they were of compensating injury victims. And so by addressing these issues, the courts essentially were attempting to fulfill their second promise, which was to correct a political failure. And the no argument for the court stepping into injury compensation law and tort law is that in general, core policy decisions should really be made by legislatures, not the courts. And with the rise of unions in the 20th century, workers actually had more than enough political clout to make their cases to the elected branches directly, rather than rely on the courts to handle these policies. So which view is right? Well, like many other things in this course, I'm not sure that there is a right answer. There's really a gray area here. And the gray area depends in large part on the prudence of the judicial decision-making process, which, as we've talked about, is very contestable. It also depends on an assessment of the politics of workplace injury compensation, which is both contested and highly complex. So is the tort case then an example of the courts acting dynamically or the courts acting in a constrained way? So clearly, there's some evidence here that the courts, in rewriting American tort law over the years as America industrialized, is an example of the dynamic court view. And so the argument is this: given changes in technology, courts were flooded with cases, right? Again, railroads much more dangerous than horses. So, given the opportunity, the courts then stepped into the void. They rewrote inherently vague tort laws twice, as a matter of fact. And in so doing, the other branches tended to follow the court's lead. Thus, we see this as a sort of classic example of dynamic courts. On the other hand, the constrained court view argues that the courts may have made policy, yes, but that its actions at sort of both points, both with protecting big business as well as turning to a system of compensation, were consistent with the broad political, economic, and social pressures of the day. And so the industrial era regime then protected businesses. The total justice era regime offered greater protections and compensation. And so it's helpful here to think about what the counterfactual might look like. What would have happened if the courts had not stepped into the void? Do you think that the elected branches would have been able to address these issues the same way that the courts did? And so what we're left with then is constrained dynamism, which is a sort of convenient way of combining parts of the dynamic court view and parts of the constrained court view. And by the way, this is something that you can use for your final paper, the case study assignment that I described earlier. So tort law, when the courts were stepping in to make policy, was very vague, right? Suggesting that doctrinal constraints were quite low. Also, the courts were not passive or checked to a large degree by the elected branches, suggesting that institutional constraints were pretty low, yet the courts did follow the ebb and flow of broad historical currents, suggesting that they were also pretty low cultural constraints faced by the courts at the time. But within those currents, the courts had a really enormous amount of flexibility to shape the specific rules of the game. And so the argument goes that judicial power was quite dynamic. The courts are very central players in the injury compensation game and have rewritten the law several times, thus making policy. But judicial coercion is a bit of a different story. And the argument could be that the courts were constrained in terms of coercing the other branches to follow their lead, and that the courts have implemented policy choices that have been consistent with broad economic pressures at the time. So during the industrial era, the courts implemented policy choices that protected big business. And during the era of total justice, the courts have implemented decisions that have been consistent with this idea that most Americans seem to hold, that they should be compensated when something bad happens. So at any rate, that is the end of today's lecture. Thanks for sticking with me. I know that that was a lot of material. I am going to post the slides for our November 7th topic, which is continuing with this theme of dealing with technology, but in terms of the environment. And so I'll post those slides hopefully in the next couple of days, and then I will see you guys in a couple of weeks on November 14th. So hope you're doing well, and I will see you soon. Thanks. Bye.